I'd like to talk a little bit today about what a personal injury claim is. The first step in understanding a personal injury claim in our American system of justice is to understand the type of remedy being sought. The justice system distinguishes between civil actions and criminal law actions. A criminal action seeks to incarcerate or limit an individual's freedom. Hence, trial results in a person paying a fine and possibly going to jail. These claims are typically initiated by a government body, a city, state, or federal body, asserting its interest on behalf of the public to force or prohibit certain acts of a person or persons. Criminal actions are not typically brought by an individual who has been wronged by another's particular act. However, many criminal actions have civil components to them. As in the O.J. Simpson case, a criminal jury acquitted, that is, found no fault with, O.J. Simpson. However, a civil jury found Mr. Simpson liable for a specific amount of money to the family of the dead defendant. There are many types of civil actions: contract and property disputes, including employment, real estate, patents, and many others fall under a category which takes up the greatest portion of legal dockets. These disputes can involve individual consumers against other individuals or large corporations against other large corporations. Corporate litigation uses a lot of court resources and often gets special treatment when it involves a particularly large specific issue. Civil claims include family law, divorce, and a host of other areas. Personal injury law is another area of civil rather than criminal law. Here, individual versus other individual, as in a car accident case, are pursued. Individual consumer versus business is also a common claim. Think of the Louisiana fishermen claims against British Petroleum regarding the 2010 oil spill. Civil personal injury claims involve a plaintiff suing a defendant for money damages. However, personal injury law has been further subdivided over the years since American jurisprudence first began. New categories like 18-wheeler tractor-trailer truck crashes, traumatic brain injuries, spine injuries, defamation, and medical malpractice are some of the divisions. The divisions arose due to the level of specialty involved. Personal injury claims involve a plaintiff suing a defendant for money damages. However, personal injury law has been further subdivided over the years since American jurisprudence began to include categories like 18-wheeler truck injuries, traumatic brain injuries, medical malpractice, defamation, and others. The reasons for these subdivisions is the level of subspecialty involved. For example, 18-wheeler or semi-tractor and trailer truck injuries involve an entire set of federal regulations specifically created in response to the industry's propensity to lack good safety protocol. These regulations are constantly being updated. Traumatic brain injury cases involve very particular scientific and medical knowledge, which is also being updated regularly as technology and medical science progress. Medical malpractice is interesting since many cases have attempted to regulate a consumer's ability to access justice for those injuries by setting limits on how claims are made. Knowing how to maneuver the legal path in these cases often requires ever-changing rules. Many consumers of the justice system seek criminal-type penalties against people or businesses that they perceive were responsible for injuring them. This, however, is the job of the state or other government body whose interest is in stopping criminal behavior. Still, in personal injury, civil cases, this differentiation is lost. The burden of proof for a criminal case is higher than for a civil case, and for good reason. When a judge takes a person's freedom of movement by putting them into jail, a jury must be very sure the evidence supports that result beyond a reasonable doubt. That's close to 100%. However, when a jury in a civil case finds money damages for one party, it does so under a preponderance of the evidence standard, and that's anything more than 50%. So if a jury finds a person 51% likely to have committed a crime, it should not find against that person criminally. no jail time. But if a jury finds a person 51% likely to have been negligent or at fault, even if by accident, it should find against him and in favor of the plaintiff. I have been practicing personal injury civil law for over 20 years. Sometimes there is a criminal component to a personal injury case. When there is, a prosecuting government attorney pursues it. While its outcome may be of great importance to the injury or civil claim, it is a separate matter. On the other hand, not all personal injury claims have criminal components, as when a party does not intend for an injury to happen. As they say, sometimes accidents happen. However, even in those unintended accidents, for example, a car crash, someone's error caused it. If you or someone you know have been injured due to someone else's fault, you do not want to rely on the criminal lawyer who works for the government to represent your personal interest. They simply do not. You should speak to an attorney who you select, since he or she will protect your best interests as to your personal injury claim.